Hello and welcome to the Disability Law Q&A with me, Martin Willemse. I'm a partner at the firm of Samfiru Tumarkin. We've got offices in Alberta, Ontario, and British Columbia. And we represent clients with disability claims, other insurance denials like life insurance and critical illness throughout Canada, other than in Quebec and the territories. So this is an opportunity for everyone to submit questions via the social media platforms. As they come in, I'll address them. We've got 30 minutes. And I'll get right into it. So one question that has come up is, what is the difference between the timeline to appeal and the limitation period? And this is something that I'm asked regularly. So during the week, throughout our offices, we have lawyers fielding questions on a free consultation basis from people who have been denied long-term disability claims. And what we do then is we review the denial letter and other medical documents that the person may have, the policy even, to discuss what the person's circumstances are and to advise them of what their opinion, what their options are, so that they can make an informed opinion as to how to proceed. And one thing that regularly comes up is when we look at the denial letter will set out, hopefully, the basis for the denial and then speak about options. One option might be an appeal, which will be detailed to some degree in the denial letter. And further down, usually it's towards the bottom of the letter, there will be a discussion about the limitation period. And people often get confused by these two. And that's not surprising because this is not something they would deal with on a regular basis. So the difference between these two things would be, if the insurance company is offering to you an opportunity to appeal the decision, that is an internal process. It's often not detailed in the policy itself, so it's not a provision in the policy that you have to follow. Sometimes it is, but for the vast majority of cases, it isn't. It's an internal process that the insurance company offers you, where it agrees to or offers you the opportunity to submit new information so that it can review its own decision. So the same entity that denied you is now going to appeal that decision or consider an appeal that you may submit. So that in itself is different from one would understand the appeal process to be. If you were to be in a legal claim and a court had made a decision and you were to appeal that decision, the appeal process would go to a different court made up of a completely different panel of judges who would have a fresh look at everything. An appeal process with an insurance company is the same entity that denied you is now going to assess whether it made a mistake. The other option, or the other timeline, is the limitation period. So with the appeal, they may say, we're going to give you 60 days or 30 days or 90 days or another specified period of time to appeal or submit an appeal. Now, if it's not something that is detailed in the policy, I always say to everyone, go back to the policy itself, because the policy is a contract. And if the appeal process is not detailed in the policy, which for the most part it isn't, it simply is the insurance company's own protocols or own imposition of timelines within which they will offer to you an opportunity to appeal the decision. So it's not contractual, it's just an internal timeline. Whereas with a limitation period, that is based on the legislation in your province. And a limitation period is a very important thing. In order to proceed with a legal claim, so say the insurance company denied your claim, you now have the option to choose to appeal, or you have an option to choose to litigate, meaning filing a legal claim, if you're in a position to do so. Some unionized employees may not be able to proceed with that process, but for the vast majority, people can. The limitation period is the timeline within which you can pursue a legal claim, completely opposite and different from an appeal process. And the limitation period continues to run. If you chose to appeal, the limitation period continues to run regardless of the appeal process. So what that means is, once the claim is denied, and depending on the Insurance Act's language in your specific province, the limitation period continues to run for a certain period of time. Usually it is 2 years. In some provinces, it may say the limitation period is triggered by the denial itself. Others may provide it is triggered from the date that you received your last payment or the date that the next payment would have been made. So it's very important to understand what the limitation period is within your province. The insurance companies in their letters may just simply say, go look at your own Insurance Act. And the Insurance Act may be hundreds and hundreds of pages with different sections and different limitation periods. So it is crucial that once your claim is denied, that you reach out to an insurance lawyer. You can contact us, and we will review with you the denial letter, and advise you of what the limitation period is. As you can see on the screen, you can go to disabilityrights.ca. The limitation period, if you miss it, you very likely will not have a claim to pursue if the insurance company continues to deny your claim. So it is a very important thing that you cannot miss. Okay, any questions related to that? By all means, you can reach out to us for further discussion. As I said, we offer free consultations on that basis as well. Talk About It is our first person to send in a question. My insurer is pushing me to attend a rehab program after having brain surgery. My doctor doesn't support this, but my adjuster said I would probably be cut off if I don't attend. What should I do? And then there's a further message that came in from Taka about it. I had a brain tumor removed and still having a long healing process ahead of me, but they are saying I should start the return to work process. This is always a difficult thing to deal with for people who are clearly struggling with something very difficult. A brain tumor was removed. Talk About It is still struggling with the recovery process. An insurance company, under the terms of the policy, may push you to participate in a rehab program if it is reasonable. They cannot simply mandate that you have to attend unless there are grounds for you to do so, would be my position. So what that would mean is, if you're still struggling and the rehab program is inappropriate at this time, have your doctor submit in writing the reasons why the proposed rehabilitation program is inappropriate. And firstly, though, have the insurance company provide to your doctor an outline detailing what the rehab program would entail. What is it that they want you to do and with whom? So that the doctor understands what it is that they want you to do, and the doctor can give an informed opinion as to why a rehab program at this time may be inappropriate. Or the doctor may say, well, I don't agree with the timeline, or I don't agree with the type of treatment. But it's not enough to simply say, I disagree. The doctor would have to, in my mind, support why the doctor doesn't agree. So set out why the program is inappropriate, why the treatment provided is inappropriate. A return to work, this often comes up. Often, I speak to people about this on a weekly basis. When the insurance company wants to have somebody attend a rehab program, and they feel, and their doctors may feel, that they're not yet ready. Because if the insurance company is pushing you to do a rehab program, the focus of that program, 100%, is to get you to a position where you can return to work, so that ultimately, if you are able to return to work, the claim will be denied. In theory, is there anything wrong with that? No. But it shouldn't be done at a time when the person is not ready to return to work, or when the person is still struggling, that a rehab program or an early return to work, even on a graduated basis, will carry with it the risk that the person will suffer a relapse or suffer a worsening of their conditions, which would then lead to a prolonged absence from work, which is counterproductive to what the insurance company wants in any event. So if your doctor sets out in writing why the rehab program is inappropriate, why it is premature, and the insurance company is still denying or still threatening that they're going to deny the claim, you're welcome to reach out to us and we can have a further discussion with you about that. But unfortunately, this is a provision in the policy, and this is something that they often push people to do. When I have these discussions, I would also speak about why that premature graduated return to work is inappropriate, so the insurance company understands if it carries with it a risk that you could hurt yourself, harm yourself, or others. Imagine you were working in a safety-sensitive occupation by operating heavy equipment, and they're pushing you to return to work on a graduated basis, where you may be taking pain medication that would make you sluggish, have brain fog, not be able to concentrate and focus, where you have to be on the ball when you operate that machinery. That is putting your life and others' lives at risk, which is not appropriate. So simply to say for the insurance company, we have this provision, you have to do what we tell you, is not correct. It has to be something that is reasonable and appropriate at the time that it is being recommended and implemented. So again, go back to the doctor, have the doctor detail in writing why it is inappropriate, and put out the risks for you and others, and with respect to a worsening of your condition if you did participate. If they do deny the claim, please reach out to us and we can offer to you a consultation. I hope that was helpful. Um, Next question is from, I think I'm missing it here. Naveen G. If insurance companies denies STD claim and when a legal action is taken, in settlement, do they pay extra to cover some legal expenses? This is a more difficult question. If you already participated in a legal claim, I suggest that you speak to your lawyer about that. Having said that, it depends on which province you are in, but if there is a resolution to your claim where the insurance company settles with you, the insurance company may agree to make something called a cost contribution. It will very likely not cover your legal fee, but they may contribute to some degree depending on how much process there has been in the legal claim. But I do suggest that you discuss that further with your lawyer if you already started a legal claim. Question on YouTube from FT Gal. I'm on LTD going on 2 years now. They sent me papers last month, and on one of them it said after 2 years they might or will cancel or change the life insurance policy that is included in my work insurance. My question is, can they do this? It's a confusing question to me because the insurance company should not be changing your life insurance policy if it is linked to the LTD policy. I'm not quite sure what that means. It might be that your employer may be changing providers, or it might be that if your claim is denied, that together with the claim, there is something called often a waiver of premium on life insurance, which is another benefit that you would have, maybe through your employment policy. So what that would mean is if you have an LTD claim and it is approved, there may be a collateral benefit under that policy called a waiver of premium on life insurance coverage. So what that means in effect is if you are deemed to be totally disabled under the terms of your LTD provisions, as a collateral benefit, you will not have to pay premiums for the life insurance benefit or coverage that you may have as long as you are deemed to be totally disabled. And if they then change their position on this, that when you come to the own occupation period ending, which seems to be the case here, that they're going to be looking at the any occupation period. In other words, they're looking at, are you disabled from working in any other occupation based on your transferable skill sets within your medical restrictions and limitations that you could perform, and that would pay to you a certain amount of money based on your pre-disability income, maybe a percentage of that, or the same as the LTD benefit. If they find, in their opinion, that you are no longer totally disabled then because you can work in another occupation as that term is defined, the waiver of life premium coverage may end as well. I hope that answered that question. The question is a bit confusing. So if you have more questions, if you want to clarify that, please reach out to us and we can have a discussion with you, hopefully to better understand what is being referred to. Okay. Susie LT says, my sister has been on LTD for a little over 1 year. She was recently at a wedding and there were photos posted online. Her insurer started grilling her about attending this wedding. We're not even sure how they know. We are guessing through social media. Should she be worried? Can they do anything because of these pictures? Social media is a gold mine for insurance companies. It all depends. This is an interesting question because I've spoken about this before in the context of surveillance. Surveillance these days, much more focused on online activity. What do people post on social media? If you say, for example, I have agoraphobia, I have an anxiety diagnosis, I've got depression, I socially isolate, I cannot leave the house, other people have to bring me food, whatever the situation may be. And then on social media, there are pictures of you doing things that you told the insurance company you cannot do. That then affects your credibility and the credibility of your claim, and probably the credibility or the weight of the opinions of your treatment providers. Now, of course, everything is not always black and white. There is gray. There's always gray. and it depends on the context. It might be that your sister, I don't know what the diagnosis is, but your sister may have had a lot of support to attend this. It may be a best friend, it may be something that she had agreed to prior and she felt compelled to, that she had to attend because she didn't want to let somebody down. It may be that there was an increase in medication to attend that one process. There may have been a worsening afterwards. It really depends on the circumstances. But I always say this: be careful what you post on social media. I have seen situations where insurance companies have denied claims based on what they saw on social media. But in those cases, often the pictures that were posted on social media were taken years before the person had become disabled. So that it was taken out of context, it was taken out of time. The insurance company misinterpreted the timeline, but you don't want to give the insurance company that opportunity. Of course, you have to be honest with your restrictions and limitations. So if you say you cannot do something, then that has to be correct. But as I said, nothing is either just black or white, there's always gray. You may have people say, I cannot do certain activities because I have a bad back. The insurance company conducts surveillance. They then find that the person, they do 5-day surveillance, they find that the person took out the garbage or they may have been mowing the lawn, where the insurance company would say, well, you told us you cannot do these things. Now we see you doing it. And my position would also always be, well, why is there not surveillance on the day that followed those activities or the day that followed that day? Because the person was struggling. People often push themselves beyond their limits because they have to participate in the activities of daily living, but they pay for it. So it really isn't that clear cut. It depends on what the surveillance shows, and often it depends on what the surveillance does not show. So if there is a denial based on this, by all means have your sister reach out to us and we can have a discussion with her as to what our options would be. I don't want to say to your sister she should be worried. She has to be honest. You say, can they do anything because of these pictures? Insurance companies are the ones making the decisions, right? So can they do anything? Yes, it's possible that they could decide to deny the claim. They may look at this with much closer scrutiny. They may be conducting surveillance now to follow this if they haven't already conducted surveillance, because the only way that they would have found out about this is they may already have done surveillance in-house, or they may have hired an investigator to conduct the surveillance, or someone else may have tipped them off, because that is something that happens as well. So I hope this doesn't lead to a denial. If it does, by all means, have your sister reach out to us and we can speak to her about what her options are and what our impression would be of what is shown on these pictures. Excuse me. Question on Facebook from Raina. My insurer has sent additional forms for my doctor to fill out to retain my LTD coverage. I would assume meaning to continue to receive long-term disability benefits. The forms say that I am responsible for the costs associated with having them completed. Can they require these forms to be done if I'm required to pay extra for these? It's an interesting question. What usually would happen is if a claim is denied and the person then participates in an appeal process, then the insurance company would say to the person, it's your responsibility. You are doing the appeal. You are responsible for the cost of all medical reports and forms and providing clinical records. That is what I regularly see. It does not happen on a regular basis. I hardly ever see this, where the insurance company tells the person that they have to pay the cost of having forms completed if the claim has already been approved or if the insurance company is in the adjudication process. So I would, if I were you, push back on the insurer and say to them, you're paying this, you're requesting this, you pay for this. You pay the LTD, you can go pay for this. Is there an actual requirement? Is there anything in the policy that says that the insurance company must pay for it or that you must pay for it? I've never seen that in an insurance policy. Again, it may be an internal protocol that they've implemented, but hopefully if you push back and say, I don't have the funds, you're investigating, so you please pay for this, that they'll agree to that. I don't know if there's a mechanism to force them to pay for it, but hopefully they will agree. Darlene 12 says, My insurer wants to do some sort of payment estimation for CPP disability benefits, and said they will deduct those payments from what they pay out. I haven't been approved for CPPD yet, so how can they start deductions? This is a frustrating situation, Darlene. It might be that they had asked you on various occasions to apply and you didn't, and only later on did you do so, that they now feel that they're going to estimate it. Or they may just be, well, it's a difficult thing to say, but each policy has a different provision. Some policies basically all of the group policies provide that CPP disability benefits are directly deductible from your LTD benefit. And it may also say that if you are eligible for such benefits and you refuse to apply, then the insurance company can summarily estimate the amount and deduct it. I think it's quite unreasonable if they were to say to you, if you haven't applied yet, or if Service Gunner is taking a very long time to make a decision, we're simply going to estimate that amount. The policy may allow them to do that to some degree, but we really would have to look at what the language is in the policy. If it says, if you refuse to apply, then we can estimate it, then on what basis would they be able to simply estimate and deduct it? Because you did apply, from what I'm understanding. So that provision would not be, in my mind, operable. It really comes down to what the provision says. So if you want to reach out to us, we can have a look at what the provision says if you have the wording. If you do not have the wording, request from the insurance company, why do you say you have the right to simply estimate the amount and deduct it directly, immediately, without a decision having been made? I have applied. You know that I did what I was required under the terms of the policy. No decision has been made. It's not my fault. Service Canada is taking a fairly long time to make decisions these days, but that's not on me. So tell me, where in the policy does it allow you to estimate the amount and to deduct it immediately without a decision having been made? Get them to provide you with that provision, and then hopefully, if you want, we can review it with you. Susie LT says, thank you very much. You're very welcome. I know it's a tough situation. Surveillance is never a fun thing, especially if you're the person at the end of it, finding out after the fact that this is what has happened. My advice to everyone is be careful what you post on social media or what others post of you on social media. Question, goodness, there's a bunch of them coming in. Question on YouTube from Erickson. Can you appeal denial if your claim was denied due to an insufficient amount of time worked? So it's an interesting question again. An insufficient time worked might be, the only way that I would interpret that question is there are pre-existing condition exclusions. And for the vast majority of policies, it would provide that if you go off work within the first year of having coverage, some policies may say within the first 2 years, but for the vast majority, it's 1 year. If you go off work within the first year of having coverage, they may deny your claim if your disability is directly or indirectly related to a sickness or an injury or a condition that existed prior to the date of coverage for which you received treatment for a specified period of time. Now, we've had discussions about pre-existing conditions basically every time we have one of these shows. They can become quite complex. It is very fact-specific. So can you appeal a claim like that? Yes, but it all depends on the facts. Another way to look at this is if I did not work an insufficient amount of time, another way of looking at that might be that in order to be what is referred to as actively at work, which is a defined term usually in policies, you are required to work a minimum amount of hours, which would be in the schedule of benefits in your policy, in order to have coverage to make a claim. No, in other words, in order to have benefits. So how this works is your policy may provide that in order to have coverage, not to have the benefits paid, just in order to have the coverage to make a claim. So you work with the employer, but you may be working 18 hours a week, where the policy requires you to work 20 hours a week in order to have coverage. If you're not working enough hours and that is the reason for the denial, then that may be a very difficult thing to overcome. Unless it is you were working variable hours. One week you were working 15 hours, another week you were working 25 hours. So there may be arguments to be made, but it depends again on the facts. But if it is, this is what this question means, that you were working less hours than is required as the minimum amount under the policy, you likely do not have a claim. But again, as with everything, you're welcome to reach out to us and we can speak to you about that, because I would want to understand the question a little bit better. Question on YouTube from Desi. I have severe migraines, pain, and anxiety. My doctors are confirming fibromyalgia. I'm supposed to return to work in September, but my job is very physical and I don't think I can return. What should I do? It's now May, so it's a few months coming up. If the insurance company is wanting to return to in September and you feel that you're not ready and your doctor agrees, it is crucial that from now until the time that you are actually going to return to work, and in any time throughout the terms of the policy, you have to see your doctor on a very regular basis. You have to make sure that when you see the doctor, you clearly report to the doctor your struggles, your restrictions, your limitations, your symptoms, so that your doctor, when September comes around, if your doctor disagrees with the insurance company that you are ready to return to work and agrees with you, because it's still a few months away, things may improve or they may not, or they may worsen. So if when September comes around and things haven't improved or there has been a worsening, your doctor can then refer back to his or her notes and provide you with a supportive, informed opinion as to why you are not ready to return to work, and substantiate that by referring back to the clinical records and advising the insurance company of what is happening, what treatment has been implemented, if you are worsening, what the plan is for treatment, if there's going to be further medical investigations or further referrals to other specialists. These are the things that are required for every policy or every claim in any event, especially when there's a return to work. I tell everybody when that happens, and if you did return to work, that should not stop. If it's a graduated basis and you return to work, continue to see the doctor very regularly and make sure that the doctor knows if there are things that happen during the time of the return to work that may lead to a worsening or new symptoms, or you find that it was just simply premature because you cannot manage the work itself, your duties. You report to the doctor this during the time that you're doing the graduated return to work, so that if you find that you have to stop, again, the doctor can be supportive of you by providing a detailed, supportive letter why it is that you have to stop working or why a return to work was inappropriate. And if they deny the claim, as with everything, contact us for a free consultation and we can advise you of what your options are. I feel that there was another one. Oh, yes. Okay, we've run out of time, but I'm going to do one more. I'm applying for LTD after being on STD. This is from Robbie BB. I was denied, which I appealed and did additional testing per their request. They are again saying I haven't provided enough information. What more can I give? This is a tough time because I do not know what the condition is and I don't know what information you have provided. Not trying to get everybody, let me rephrase that. I would want to know more information. So Robbie BB, I suggest that you contact us, because if short-term was denied and it is paid and LTD is the same insurance company, you can take the position that by refusing to pay you short-term or approving the short-term, they're effectively preventing you from applying for long-term, which may allow you to pursue a legal claim. But it really depends on the circumstances. If somebody submits a claim for short-term and the doctor, let's use a mental health example. The doctor says my patient has anxiety and depression or burnout and they cannot work. That claim is going to be denied. This is not a workplace situation where you would give a note to the employer and say my patient has to be off work for a period of time due to a medical condition. With an insurance company, you are the one who has to support why it is that you cannot work. In other words, the duty is on you to prove that you fall within that definition of total disability. So if your doctor submitted that form, you then went out and you got some clinical records, and the doctor simply made another note, that's what the problem would be. So in order to convince, hopefully, the insurance company that you cannot work, you would have to go to your doctor and have your doctor write a detailed letter advising what your diagnoses are, what your job duties are, and this is the most important part, what your restrictions and limitations are, what your symptoms are, how they impact your ability to function in the workplace, even outside of the workplace, what treatment has been implemented, and then support why it is that you cannot perform those duties. That's what a supportive opinion would look like. It's not enough to say my patient has these conditions, therefore they cannot work. The doctor has to detail it, and you as well. If the insurance company still denies your claim, you may have an option to pursue a legal claim, because remember, they are the ones who are reviewing the appeal process. You've already gone through this. You did a claim, they denied it. You appealed, they denied it again. Now you want to give them more information to try and convince that same entity who denied you that they are now going to approve it. So I strongly suggest that you reach out to somebody in our firm, contact the intake people, and they can refer you to a lawyer to discuss what your options may be. I hope that is helpful. Thank you, everybody, for tuning in. So, what do I say? The next Q&A is a employment law Q&A on Wednesday, May the 28th at 1 p.m. Mountain Standard Time, with Haley Auger. And the next disability law Q&A will be with me on Tuesday, June the 10th at 10 a.m. Pacific Standard Time. So basically 2 weeks from now. Thank you again for all your questions, and I wish everybody a good week. Goodbye.